I was 38 years old the afternoon I found a document on a microfilm reel that stopped a $380,000 real estate sale and returned my mother to a house she had not been allowed to enter in 22 years. The document was filed on a Tuesday in April of 2001. I found it on a Tuesday in June at 2:14 in the afternoon because my job is to read things that have been waiting to be read for a very long time. But this story really starts in 2004. At a probate hearing, my mother was not called to attend. My name is Paige Elmore, and I am 38 years old. I work in the deed research room at the Kearney County Recorder's Office in Wisconsin. My job, in plain terms, is to trace chains of title, to follow a piece of land from one owner to the next through decades of handwritten entries, transfer documents, mortgages paid and mortgages released, until you have the complete legal history of who owned what and when. I read microfilm. I read abstract books. I spend hours with documents that were typed on machines that no longer exist, notarized by clerks long since retired, witnessed by people whose own properties have since changed hands twice over. I decipher stamps that are partially obscured by humidity damage. I find handwriting from 1962, and I read it carefully, and I understand what it means, and I write it down in a form the current century can use. I am very good at finding things that are technically in the public record, but have been effectively invisible for years. Not because they were hidden, the recorder's office makes no secrets, but because you have to know what to look for, and you have to be sitting in front of the right reel on the right afternoon, and you have to slow down when something in the corner of the frame does not belong to the property you were looking for. My grandfather, Norman Elmore, built the house at 18 Birch Lane in Kearney Junction in 1978. He built it himself, over 2 summers, with help from 3 men from his church. He was a finish carpenter by trade, and the house showed it. Wood trim around every doorway, floors that never creaked, a staircase that went up the right way. He lived there for 26 years. He died there in the spring of 2004. On a Thursday morning in April, in the bedroom he had slept in for a quarter century. My uncle Chet Elmore, Norman's only son, handled the estate. Chet is organized, efficient, and has always known what he wants. He moved fast after my grandfather died, filed the probate inside the 90-day window, hired an estate attorney, had the house transferred into his name within 7 months of Norman's death. He and his wife Sandra have been renting it out since 2006. They kept it well enough. The maple tree Norman planted in the front yard the summer my mother was 4 is still standing in front of it. Last spring, they listed the house at $380,000. They received an offer and went into contract. What Chet did not know, what his attorney did not know, what nobody involved in the 2004 probate proceeding had apparently known, was that on a Tuesday in April of 2001, Norman Elmore had driven himself to this building, to the 2nd floor of the county recorder's office where I now work, and had asked the clerk at the counter for a homestead affirmation form. He had filled it out himself, in his own handwriting. He had paid the $3 recording fee. The clerk had notarized it and logged it in the same afternoon. Norman had gone home. The document named my mother, his daughter Ruth, as a remainderment interest holder in the property at 18 Birch Lane. This document was in the public record. It had been there for 23 years. No one had looked for it because no one had known to look. I know this because looking for things like this is what I do for a living. What happened when I found it? What a retired attorney named Victor Ossie did with a single phone call, what the title company's underwriter did with a title search, and what my uncle did not understand until he was already sitting at a closing table, is the kind of thing that does not announce itself. It moves through the correct channels at the correct pace, and one morning the channel arrives at an outcome and delivers it to the people who need it. Nobody saw it coming from the archivist's desk on the 2nd floor. Welcome to the channel. If quiet, documented justice that works through the system instead of around it is your kind of story, you are in the right place. Drop a comment and tell me where you are listening from, and hit subscribe. Let me back up. My mother, Ruth Vander, she took her second husband's name when she remarried in 1994, a good marriage that lasted until his death in 2015, is 64 years old and lives in a small house in Mineral Springs, 30 miles from Kearney Junction. She taught second and third grade for 31 years at the same elementary school in Mineral Springs and retired in 2021. She has a garden in the backyard that she tends carefully. She has 3 cats. She makes excellent lemon cakes. She does not talk about her father's house on Birch Lane. She was estranged from her father in the years before his death. This is not a simple story, and I will not flatten it into one. There was a misunderstanding that became a rupture, that became a silence, the way those things sometimes do in families where neither person is truly wrong and neither person knows how to begin the repair. My grandfather was a man who felt things deeply and expressed them infrequently. My mother is a woman who gives freely and holds her ground quietly. When they stopped speaking, in 2001, the immediate cause was a disagreement about money. Chet had borrowed from my grandfather, and my mother had raised the question, once, privately, of whether Chet intended to repay it, and my grandfather had taken this as an accusation rather than a concern. That is the version I know from my mother. I cannot speak to what my grandfather believed had happened. What I know is that neither of them moved to repair it before time ran out. He died in April of 2004. My mother was not called. She learned about it from a cousin, 3 weeks after the funeral, when she telephoned to catch up on family news and was told her father had already been buried. She did not go to the grave. She told me she could not then. She said that walking into the churchyard and finding a stone with his dates on it, dates she had not known, felt like being excluded from something a second time. Chet filed probate within the month. He had been named executor in the will. The will itself was straightforward, the house and remaining assets to the son, with no special provisions. It was filed and moved through the system. My mother did not contest it. She told me, years later, that she did not believe she had legal grounds, and that even if she had, she could not have afforded to fight it, and did not have the heart to turn something that was already painful into something that required years of her life on top of everything else. She had never seen the document from 2001. I had never known it existed. This is what I mean when I say my job is not only about reading documents, it is about understanding what documents people do not know to look for, because they did not know something was ever put there in the first place. I found out about the sale from a neighbor of Paul's. Paul is my husband. He had been at the hardware store on a Saturday morning in March, talking with someone whose wife taught school with someone who lived 2 streets over from 18 Birch Lane. The house had a sign in front of it, Kearney Realty. Chet was asking $380,000. They had accepted an offer. A closing was being scheduled. I mentioned it to my mother over the phone that Sunday evening. We talked every Sunday. I told her as gently as I could, framing it as information I thought she should have, rather than news that required a response from her. She was quiet for a long time. I could hear her kitchen. Her refrigerator has a particular hum that I have known since I was a child. She has a clock above the stove that I have also known since childhood. Those sounds did not change. Then she said she supposed that was his right. It was his house. He had owned it for 20 years. She said she had driven past it once, years ago, just once, on her way back from an errand, and it looked the same. The maple tree in the front yard that her father planted the summer she was 4 was still there. I said I was sorry. She said there was nothing to be sorry about. That is what my mother does. She says there is nothing to be sorry about. It is one of her most consistent qualities, and one of the things I have had to learn, slowly, is not to mistake it for acceptance. I went to work Monday morning. The research project I was working on that week was an abstract request for a commercial property 4 blocks south of Birch Lane, a dry goods building constructed in 1941 and changed hands 6 times since. Standard chain of title research, going back 80-some years, pulling every instrument recorded against the parcel. When you work in a county recorder's office long enough, you develop a specific kind of peripheral attention that functions without quite being conscious. You are not looking for things connected to your own life, but you are aware of the geography, the street names, the subdivision names, the neighbors of the property you are researching, the names that recur in a given section of the grid. The abstract work pulled me into Reel 2001C, which covers deeds recorded from April through August of 2001 for sections 8 through 14 of the city grid. The commercial property I was working on was in section 9. Birch Lane is in section 11. They are in the same reel. I was moving through the reel on a Tuesday afternoon in June. It was a quiet day. Fran Dietrich, my supervisor, was at a county records conference in Madison. The deed room was nearly empty. I had my second cup of coffee beside me. I was going frame by frame, the way I always do, noting the instruments that fell within my target parcel's block. It was 2:14 p.m. I have the log entry. The timestamp is not something I added after the fact. I stopped. The document on the screen was not the one I was looking for. It was in the wrong section. I should have moved past it. But something about the handwriting caught me. The deliberate, careful hand. I recognized the way you recognize a familiar voice before you can place the name attached to it. It was in Norman Elmore's handwriting, not just his signature, the entire body of the document, written by hand, because a homestead affirmation permits the declarant to write it themselves if they choose, and Norman had chosen. He had not had a lawyer prepare this. He had come to the desk on the second floor and asked the clerk for the correct form, and filled it out himself, and paid the fee, and left, the way a man does when he has decided to do something quietly and on his own terms. The document identified the property at 18 Birch Lane by its full legal description, section, parcel, lot number. It named Norman Dale Elmore as the fee simple owner. And in the section headed Statement of Interest held in reserve by declaration, in his handwriting, it said, I, Norman Dale Elmore, hereby declare and affirm that my daughter, Ruth Elmore, shall hold a remainderment interest in the above described property, such interest to be effective upon my death, or upon any conveyance of the property by my estate, and to survive any instrument of transfer that does not expressly terminate this interest by name. He had signed it on a Tuesday in April of 2001. The notary stamp belonged to a clerk who had worked the desk downstairs. The recording fee receipt, stapled to the corner of the copy, showed $3. I looked at the screen for a long time. I was aware of the particular stillness of the deed room in the afternoon, the low sound of the fluorescent light above the microfilm reader, the smell of the archive, paper and old binding, and the specific neutrality of a room that holds records and nothing else. I looked at my grandfather's handwriting, which had not changed at all from the way I had known it as a child, when he wrote Christmas cards and notes tucked into birthday cards, and once, when I was 10, a letter to my school explaining that I had missed a week because of a family matter, written in that same careful, upright hand. He filed this document in April of 2001. He and my mother had stopped speaking in the fall of 2000. He filed it 3 years before he died. I have worked in this office for 11 years. The thing 11 years teaches you, above almost anything else, is the precise and essential difference between your professional role and your personal interest. These are not things you blur. They are not things you trade against each other. Your job is your job, and your family is your family, and where they overlap, you declare it, and you step back, and you let the system be the system. I did not sit with the document for long. I printed it from the reel. I brought it directly to Fran's office. She was at the conference, but she had a deputy on site, and I explained that I had found a recorded instrument connected to a property that involved my family, and that I could not continue on any file that touched that parcel, and that the parcel should be flagged. The deputy reviewed the document and confirmed the flag. She said that if a title company was currently running a search on the property, the flag would surface in their pull. I said, there is a title company running a search on this property right now. It is in contract. She said, then they will find it. I walked back to my desk. I sat down. I looked at the window. The deed room has 2 windows that face the parking structure, which is not a beautiful view, but it is a view, and sometimes that is enough. Then I looked up Victor Ossie. Victor Ossie had been Norman Elmore's personal attorney from 1987 until his retirement in 2008. He was in private practice in Kearney Junction for most of those years, in an office on Meridian Street that I remember from childhood as having dark wood paneling and a secretary named Mrs. Holt, who always offered me a peppermint from a dish on the corner of her desk. Victor handled Norman's will, 2 property easement disputes, and the full documentation of the 2001 homestead affirmation filing. He is 77 years old now and lives in the town of Pemberton, on the far side of the county. He does not practice law. I found him through the state bar's inactive registry, which is a public document. I called his home number on a Thursday afternoon, between 2 unrelated research assignments, on a phone call I thought would last 10 minutes. He answered on the 3rd ring. I introduced myself. I said I was Norman Elmore's granddaughter and that I worked in the Kearney County Recorder's office. I said I had found a document my grandfather had filed in April of 2001, and I wanted to understand its context. There was a pause. The particular quality of a pause from someone organizing something they have been carrying for a long time. Then Victor Ossie said, "I remember that filing." He told me that Norman had come to see him twice in the months before he filed the affirmation. The first visit was to ask what options existed for protecting a specific heir outside the terms of a will, in a situation where the will was already drafted and the heir might not contest it. Victor had walked him through several instruments. The homestead affirmation of remainderment interest was the one Norman had settled on. Clean, simple, inexpensive, on the public record, and difficult to overlook in a thorough title search because the parcel flag system existed precisely to surface it. The second visit was to have Victor prepare a letter of attestation in case the document's context was ever questioned. Victor had prepared the letter and notarized it and given it to Norman and filed a copy in his own office records. He said, Norman did not want to put this into the will because he was worried about a contest. A will can be contested. A homestead affirmation in the public record is harder to argue with. He wanted it somewhere that would wait for whoever needed it. I said, "It did not come up in probate." Victor said, "I know. I was not retained for the estate." I assumed Chet's attorney would have run a thorough abstract. I said, "They did not find it." There was a longer pause. Victor Ossie said, "When is the closing?" I said I believed it was 6 weeks out. He said, "I will contact the title company." I said I had not given him the name of the title company. He said, quietly and with a certain finality, "I know every title company that works Kearney Junction. I have been retired for 18 years, and I still know every one. I will make some calls." I thanked him. I said goodbye. I sat at my desk for a moment with the phone still in my hand. Then I put it down and went back to the commercial abstract I had been working on. I want to stop here and be honest about a decision I made in those first hours. There are people who will say I should have called my mother the afternoon I found the document. Maybe they are right. I have turned it over many times. My mother had not had contact with the Elmore family in 22 years. The house on Birch Lane was something she had laid down and left behind because holding it was too heavy. To call her before I knew whether the document was legally actionable, before I knew whether the parcel flag would surface in the title search, before I knew whether Victor Ossie would respond the way he did, felt like raising a possibility only to watch it fail in front of her. It felt like a cruelty shaped like hope. I wanted to know whether the stone was going to land before I told her I had set it rolling. You can decide whether that was the right call. I am genuinely not sure. 6 weeks is a long time in a records room. I did my regular work. I fielded questions from the public desk. I assisted 2 attorneys with instrument searches on unrelated parcels. I trained a new filing clerk on the microfilm protocol for pre-1990 deeds. Fran came back from the conference and I briefed her on the Birch Lane situation in full. She reviewed the parcel flag and confirmed it was properly entered. She said if the title company pulled the section block, they would find it. She did not ask me how I was handling it personally. Fran is not that kind of supervisor, which is something I respect about her. At home, I cooked dinner. I talked to Paul about his week, his sister's visit, whether the garden needed more mulch. I called my mother on Sundays the way I always did. We talked about her cats and her tomatoes, and a book club she had joined at the library in Mineral Springs. She was reading something she had picked up on a friend's recommendation and was not sure yet whether she liked it, but was giving it more time. I did not tell her about the document. There is a closing date on every real estate transaction. There is a buyer who has arranged financing and is waiting. There is a seller who has already spent the proceeds in some part of his mind. And somewhere in the office of Fern and Wicker Title Services on Route 9, a search is running on parcel 1108142, Section 14, Kearney Junction, Wisconsin. I did my job. I waited. If you have ever done the right thing and then had to sit with the waiting, not knowing how it would arrive, drop a comment and tell me where you are from, and hit subscribe. The part that changed everything is coming. I found out what had happened at the title company the same way most things in this story reached me, indirectly, at an ordinary time, in a professional setting. Fran came to my desk on a Thursday morning, 3 weeks before the originally scheduled closing date. She said the parcel flag had been pulled. Fern and Wicker had run their section search. Their underwriter had flagged the 2001 Homestead Affirmation of Interest as an unresolved instrument against the property. A recorded interest holder had not been disclosed in the 2004 probate proceeding. The title company could not issue a clean title policy until the interest was either extinguished by agreement or addressed by the court. She said she did not know what was happening on the seller's side, but that the closing would not proceed as scheduled. I said thank you. I went back to the abstract I had been working on. That afternoon, Victor Ossie called me at the office number. He said he had spoken to Fern and Wicker's underwriter 2 weeks prior and had walked them through the full context of the 2001 filing, including the circumstances of Norman's decision to file it, and the existence of the attestation letter he had prepared and retained in his own records. The underwriter had reviewed both documents and confirmed that the instrument created a valid remainderment interest that had not been extinguished during the probate proceeding. Victor said, Ruth Vander, legally Ruth Elmore, in the context of the original instrument, holds a recorded interest in the property that cannot be conveyed without her signature or without a court order extinguishing it. He said he had also sent a copy of his attestation letter directly to the title company's underwriting team. He had not been asked to do this. He had done it because he thought it would move things forward more cleanly than waiting for the parties to request it. I said, Mr. Ossie, why? He said, because your grandfather asked me to help him protect his daughter. I retired thinking that job was done. I would like to know that it was. I called my mother that Sunday evening. I told her I had found something at work. I said I needed to explain a few terms before the rest of the story would make sense. I explained what a homestead affirmation of interest was. I explained what a remainderment meant in practical terms, that it was a right to inherit a property interest that attached at the original owner's death, that it was not a gift, but a legally recorded claim. I told her that her father had filed such a document in April of 2001, 3 years before he died. She said, in April of 2001. I said, yes. She was quiet. I heard her refrigerator. I heard the clock. She said, that is when we stopped speaking. I said, I know. She was quiet for almost a full minute. Then she said, he filed it himself? I said, yes. He came to the recorder's office. He paid the filing fee. He wrote it in his own handwriting. My mother said, very quietly, he did not tell me. I said, no. She said, we were not speaking. I said, I know, Mom. She said, he made sure, anyway. I said, He made sure. This is the moment I think about most when I think about this whole story. Not the closing that stopped, not my uncle's phone call, not the legal resolution. This moment. My mother sitting in her kitchen in Mineral Springs, understanding that in the fall of 2000 she and her father had stopped speaking, and that the following spring, without telling her, without knowing whether they would ever reconcile, her father had driven across town to a government building and had filled out a form in his own careful handwriting and paid $3 and had done the one thing left to him that was within his power to do for her. After I hung up, I sat on the couch for a long time in the quiet of my own house. I am a person who works with documents. I think about documents the way some people think about faith or about institutions. Not as infallible things, but as things that hold certain kinds of truth in a form that lasts past the person who recorded it. A document is not a relationship. It is not forgiveness. It is not a conversation between two people who needed to have it and did not have it in time. But a document is a record of what someone chose to do. And what someone chose to do, on a given day, in a given context, is a fact that does not change. It waits in the archive. It does not degrade. It is there when someone with the right tools and the right attention sits down in front of it. My grandfather could not unsay whatever had been said. He could not make the years of silence unhappen. But he could get into his truck on a Tuesday morning and drive to the county recorder's office and ask for the form, and fill it out in the handwriting I had known since before I could read, and file it in the place where such things are kept, and trust that it would be there. I am the person who found it. I do not know whether that is meaningful in a larger sense. I do not need it to be. What I know is that the act of recording something correctly, in the right place, at the right time, for the right reason, is not a small thing. It is the foundation of every property claim that has ever stood. It is why the recorder's office exists. And on a Tuesday afternoon, at 2:14 p.m., it was why Norman Elmore's $3 filing was still there, waiting, 23 years later, for someone who knew to slow down when they reached Section 11. The original closing date passed. Fern and Wicker could not issue title insurance. The buyer's financing lender put the loan on hold pending resolution of the title defect. Chet's attorney filed a motion in probate court to extinguish the 2001 instrument, arguing that it had not been disclosed or acted upon during the original probate proceeding. This is a recognized legal strategy. It did not succeed. The court found that an instrument properly recorded in the public record does not extinguish because of an omission in a subsequent proceeding that failed to discover it. The instrument existed before the probate. The probate did not void it. Ruth Elmore's recorded interest survived. Chet called me. He said, "You did this." I said I had found a document in the course of normal archival research, reported it through the correct professional channels, and recused myself from the file. That was the full extent of what I had done. He said, "You went looking for it." I said, "I was pulling Section 11 on Reel 2001C to research a property on Deering Street. The reel covers the whole section." He said some other things. Some of them were loud. I listened until he was finished, and then I said, "Chet, I think you should speak with your attorney." I hung up. Here is what happened after. Chet's attorney and my mother's attorney. She found a woman named Patricia Norwood in Mineral Springs, an estate attorney who came highly recommended, negotiated for 11 weeks. The resolution they reached, my mother would sign a quitclaim on her remainderment interest in exchange for a payment of $72,000, representing the agreed appraised value of her proportional interest in the property. She did not receive the house. That was never the realistic outcome, and it was not what she wanted. What she received was formal, written acknowledgement, documented, signed, and filed in the same recorder's office where the original affirmation had sat for 23 years. That her father had named her, that the interest was real, that it had been real the whole time, that it had value. Chet completed the sale. The buyer received the property. The maple tree in the front yard is still there, I assume. I have not driven past. My mother used part of the settlement money to take a trip to Portugal, which is somewhere she had wanted to go since she was 30. She spent 12 days there in the autumn. She sent me photographs. She was in a small restaurant in Lisbon, at a table by a window, and she was looking at the camera with the particular expression she gets when she is actually, genuinely, rested. I have been looking at people's faces for 38 years. I know that expression from her. She has been to Kearney Junction twice since the settlement. She has not asked to go to Birch Lane. She did go, once, to St. Matthew's Cemetery, on a November afternoon, when the weather was cold but clear. I went with her. She had a small rosemary cutting in a plastic pot, which is what she had decided to bring. She planted it at the edge of the marker and pressed the soil down around it with both hands, carefully, the way she has always done things, with the full attention of someone who intends the thing to last. She did not say anything at the grave. She did not need to. Victor Aussie sent me a card, 3 weeks after the settlement closed. A plain card. One sentence in the middle of it. Tell Ruth that her father's paperwork was impeccable. That is all he wanted it to be. I had it framed. I gave it to my mother at Christmas, wrapped in brown paper. She read it standing in her kitchen. She held it for a long time. She has it now on the mantel above her fireplace, next to a photograph of the Lisbon restaurant. Chet and I have not spoken since the phone call. I am not sorry about that. I am sorry it came to this, in the sense that I wish the 2004 probate had been done properly and this had never needed to happen. I am not sorry I slowed down on Reel 2001C at 2:14 p.m. on a Tuesday in June. Here is what I want to give you from this story. The things that are put in the right place at the right time do not disappear. A $3 recording fee, a handwritten form, a notary stamp from the clerk at the counter downstairs. These are not impressive objects. They are not gestures of great drama, but they are correct, and what is correctly recorded in the public record does not expire. My grandfather could not fix what was broken between them. He could not make the silence unhappen or the years come back. But he could do the one thing left within his power, and he could do it correctly. And he could trust that the system he was filing with would hold it until it was needed. I am the one who found it. I work on the second floor of the same building where he filed it. I sat down at the right reel on the right afternoon because my job took me there, and the section system meant his block was adjacent to the one I was working in. Some things are in the record, waiting. They wait without knowing they are waiting. They wait the way all correctly recorded things wait, patiently, accurately, and without requiring anyone to remember them.